claimants in paragraph 27 of the statement of facts aver that the defendant had stopped further payments to them since December 2013, leaving the outstanding unpaid balance of the 17.9 million, despite several demands made by them. But what happened in this case is that they failed to state the specific time and when the defendant stopped the payment. They equally failed to specifically canvass evidence to show how much they have been paid. The documents, on the other hand, contended that the claimants do not have the legal competence. Sorry, the defendants, on the other hand, contended that the claimants do not have the legal competence to prepare any fiscal list of any sort without any input of the first defendant who effected the payment of their severance and other allowances. Hence, they do not have any knowledge of outstanding balance left unpaid. The defendant further stated that the claimants have been fully and completely paid their severance and all other allowances. One thing is clear from the evidence presented before the court, and that is an admission of liability or indebtedness on the part of the defendants and the admission on the part of the claimants that they have been paid part of the allowances. The only contention here is that while the claimants allege that they were only paid part and still have outstanding sum unpaid, the defendants are insisting that they have fully paid the claimants. The law is right that he who asserts must prove. See the case of Webo and another versus Okeke and others citation is provided. The case of Okebu and others versus Abga and others citation is also provided. The case of Ario and others versus Julius Berger Nigeria Limited and another citation is equally provided. The onus of proving that the claimants are still owed outstanding allowances by the defendant solely rests on them and not on the defendant. Now have the claimants proved the relief sought? The position of the law is that a party seeking for a declaratory relief and monetary claims, as in this instance, has the onus of proving with cogent and credible evidence these claims. By the case of Hotoro and another versus Shaku and other citation is provided, it was held by the court that a declaratory relief pronounces on the rights of the claimant in respect of a thing or situation in a general sense and stops at that. See also the case of Ararume and another versus INEC and other citation is provided, where it was succinctly put, thus I quote, the main object of a declaratory relief, which eventually is equitable in nature, is the pronouncement of an existing state of affairs in law, unquote. In the case of Kuburi International Trapping Company Limited and another versus Bulama Mosti and another citation is provided, Omaleye JCA held those, and I quote, the main purpose of a declaratory relief sought from the court is essentially an equitable relief in which a claimant prays the court in exercise of its discretionary jurisdiction to pronounce on existing state of affairs in law in his favor, as may be discernible from the averments in the statement of claim or counterclaim, as the case may be. For a declaratory relief is confined to cases where there is a complete or subsisting cause of action, but may be employed in all cases where the claimant concedes he has a right, unquote. The claimants, by the documents tendered, have shown that they are entitled to be paid severance and other allowances as ex-political office holders at Adavi local government area between 2004 and 2007. That is not in contention, as I've stated earlier. The import of this is that they are entitled to these allowances and should not ordinarily be withheld from them by the defendants. Whether or not they are able to lay claim to them by preferring credible and substantial evidence in proof of sale is to be considered hereafter. It is also evident on record that part payment of certain amount of money were admittedly paid to the claimants by the defendants. It is therefore in the light of this that I resolve relief 1 in favor of the claimants. Next, I would want to consider reliefs 2 and 3 together, which are seeking for order of court for payment of the sum of 17,901,031 naira 70 kobo, allegedly being the outstanding severance allowance due to them, and that the defendants cannot withhold same from them. In support of this release, claimants sent letters written by the first defendant to First Bank to deduct 1 million naira monthly from their account for the payment of the claimants and their colleagues. They equally tendered a letter dated 11th of May 2015, addressed to the Commissioner for Local Government, that is Exhibit J7, attached are computations of their entitlement made by them personally, and the sub-receipt evincing payment of 41,500 naira to each of the claimants and their colleagues for June 2009 and July 2011. Also front-loaded are 3 check leaves, 2 from FCMB Bank, dated 25th of October 2013 and 20th of December 2013, respectively, each in the sum of 1 million naira. The first check, as stated already on record, is the one from Oceanic Bank, dated 28 July 2011, also in the sum of 1 million naira. Are these sufficient and credible enough to substantiate claimant's claim for an outstanding sum of 17,901,031 naira 70 kobo? In actual fact, the 3 checks tendered are not sufficient to substantiate the sum of 22,876,414 naira 79 kobo allegedly paid to them, for which they are seeking for the balance of 17.9 million naira. The law is that the claim for monetary relief must be specifically pleaded, particularized, and strictly proved. This claim is in the realm of special damages, and to be recoverable, it must flow directly and immediately from the breach of contract and must be reasonably foreseeable. They are exceptional in their character and connote special items of loss, which the claimants alleges are the result of the defendants. Are the result of the defendant's act of breach of duty complained of. See the case of Mobile Producing Nigeria Unlimited and the case of and Davison, and another citation is provided. It is worthy of note from the evidence on record that the claimants have woefully failed to substantiate their claim for the sum allegedly outstanding to be paid to them. The checks tendered only show that they were paid 1 million naira each at different times between 2011 and 2013. The schedule of payment and outstanding payment prepared by them cannot in any way support their claim. This is in view of the fact that it does not lie in their power to sit somewhere and prepare such a document without confirmation by the defendants or the banks. I say so in view of the decision of this court in the case of Mr. Olopade, Samuel Olatunwo Oyebola and others versus FAAN on reported suit number NICN/LA/259/2013, judgment of which was delivered on the 20th of May 2019. It was held in that case that on self-generated exhibits, I quote, Exhibit C14 and C15 are the computations made by the claimants themselves as to their respective 2006 furniture claim and severance claims. Exhibit C14 and C15 are self-generated and so cannot be proof of the claimant's claim for furniture and severance claims. See Peter Yinkore and 73 others versus Nikonde Energy Limited and another on reported suit number NICN/LA/611/2015, the judgment of which was delivered on 12th of February 2019 at paragraph 107 unquote. The claimant did not tender any document from the banks to evince that they were indeed paid the sum of 22,876,414 naira 79 kobo, leaving a balance of 17,591,876 naira 71 kobo. I find that the claimants are not definitely sure of the outstanding balance of their allowances. I say this in view of the fact that by Relief 2, they are claiming the sum of 17.9 million naira, while at paragraph 28 of their statement of fact, they are claiming the sum of 17,591,876 naira 761 kobo as the balance outstanding. These are clearly two separate and distinct sums of money. It goes to show that they are not too sure of the exact amount outstanding to be paid to them. In fact, The claimants could not prove to the satisfaction of the court that they are being owed the sum claimed. Claims of this nature are not granted as a matter of course. They have to be adequately proved. The claimants have the onus to proffer credible evidence and/or call witnesses in support of their claim. They are at liberty to subpoena staff of the banks where they receive their part payments to produce evidence of such payments in court and then proceed to show the court their entitlement to the sum claimed. This they woefully failed to do as stated herein before. What more, claimants are not quite sure of their positions in the first defendant. I find this so in view of the averment at paragraphs 1 and 21 of their statement of facts, whilst at paragraph 1, they stated that the first and second claimants were supervisors, third, fourth, and fifth claimants were special advisors, the sixth and seventh claimants were counselors at paragraph 21. The first, second, fourth, fifth, and seventh claimants were said to be special advisors and supervisors. The contradiction is so apparent that is equally fatal to their case. This is because when the party's evidence on material fact is inconsistent or contradictory, it would not cast serious doubt. It would cast serious doubt on the veracity of the party's case, and the court will be justified to disbelieve the party. This is simply because the court cannot pick and choose which piece of inconsistent evidence to believe and give effect to. See the case of McCann versus Dennis and other citation is provided. The contradiction in this instance is material in that the allowances for a counselor is different from that of a special advisor or special assistant. This in effect will equally affect the amount allegedly outstanding to be paid to the claimants. It is from all the reasoning above that I have no hesitation in making a finding that the claimants have failed to substantiate with credible evidence their claim for the sum of 70 million, 901,031 naira, 70 kobo. The same fate is to befall their relief 3, and that having failed to prove their entitlement to the sum claim, they cannot be granted relief 3. It is in consequence that reliefs 2 and 3 are thus discountenanced. Claimants by their reliefs 4 and 5 are seeking for an order of perpetual injunction restraining the defendants, their agents, privies, or anybody acting through them or on their behalf from withholding the payment of the said severance allowances and other allowances due to the claimants as former or ex-political office holders who had held various positions in the Adavi local government as directed by Revenue Mobilization, Allocation and Fiscal Commission and approved by Kogi State House of Assembly, and also urging the court to award 21% interest on the outstanding allowances. It is a law of commonplace that the grant of relief or perpetual injunction is a consequential order which should naturally flow from the direct declaratory order sought and granted by the court. The essence of granting a perpetual injunction or final determination of rights of parties is to prevent permanently the infringement of those rights and obviate the necessity of bringing multiplicity of suits in respect of every repeated infringement. Put differently, for an order of perpetual injunction to be granted, the claimant has to establish by credible evidence that he has a right to be protected by the grant of the injunction. See the case of Goldmark Nigeria Limited versus Ibafon Company Limited. Citation is provided. The case of Honorable Minister FCT versus Fayode and another citation is also provided. It has been held supra that the claimants have failed in canvassing credible evidence in proof of their monetary claims. Hence, their main claim for their alleged allowances equally failed. The consequence of this is that the court cannot make any consequential order in respect of an unsuccessful claim. There is no need for making such an order prayed by the claimants in vacuum. The same fate befalls claimants relief 5, which is for payment of interest on the sum claimed. It is so apparent from all stated herein before that the claimants are not entitled to any interest on any unknown or unproven outstanding sum. It is in the light of the above that I find it expedient to refuse claimants relief 4 and 5 as well. In conclusion, it is obvious from the decision in this case that the claimants failed to prove all the relief sought, except their relief one. Accordingly, the claimant's case is dismissed. Judgment is accordingly entered.
At court basis. Lord, we are entirely grateful for this detailed judgment given. We are very grateful, my Lord. Lord, we want to a little bit apologize for the introduction.
You have muted yourself, Mr. Obaide. Unmute yourself. Go ahead.
Yes, Lord, we are very grateful. My Lord, we are very grateful for the judgment, for the detail, indeed, very grateful. Lord, we want to apologize for the introduction I did initially, the appearance, my Lord. I'm actually holding the brief of Zedi Abbas.
Holding the brief of Debbie Abbas.
Yes, my Lord. I'm very grateful, my Lord.
Very well.
Thank you, my Lord. My Lord, we are grateful. Welcome back on the text.
Thank you. So you may, you are entitled to copy of the judgment, and that will be sent to Lokoja by next week.
We're grateful. Thank you.
Well. Call the next case. The next case is Association of National Olympic Committee of Africa and Mr. Mohammed Azog and International General Lassana Palemfo are parties in court.
A lot of parties are absent.
Very well. Can I have the appearances?
Respectfully, my Lord.
Representation.
Yeah. Respectfully, my Lord. N.F. John.
Go ahead.
N.F. John, my Lord, for the claimant. I apologize for the absence of the claimant. I'm most grateful for the indulgence.
Any other appearance?
Yes, my Lord. Please, my noble Lord.
Very well.
My name is M.J. Numa.
M.J. Umar.
Numa. Numa is spelled N-U-M-A. Yes, my Lord.
Very well.
Much obliged. My Lord, my learned friend with me, B.J. Tabai.
B.J. Tabai. Very well. Any other person with you?
B.J. Tabai. Just B.J. Tabai.
Yeah. Okay.
We both represent the defendants.
For the defendants, very well.
We're grateful, my Lord.
Here is the ruling of the court.
As God pleases.
By a general form of complaint dated 5th of September 2019, the claimant claims against the defendants praying for the following relief. A declaration that upon the expiration of the first defendant's contract of employment with the claimant, which came to an end on the 31st of November 2016, the second defendant lacked the power and legal competence to unilaterally extend the first defendant's contract of employment with the claimant till December 2020, without the second defendant being expressly authorized by the claimant's executive board or constitution, and more particularly, without compliance with the claimant's basic standard of contract. B, a declaration that the purported fixed term of employment contract dated 1st of January 2017 with reference number HDQ RS A-ANOCA.PD/PDT/0017 unilaterally donated and executed by the second defendant purporting to act on behalf of the claimant in favor of the first defendant is invalid, unlawful, and of no legal effect whatsoever, as the second defendant is divested of such powers, as well as for non-compliance with the claimant's basic standard of contract, therefore making the aforementioned letter of fixed-term employment contract liable to be set aside. C, a declaration that the first defendant acting in connivance or in concert with the second defendant fraudulently procured the purported fixed-term employment contract dated 1st of January 2017 with reference number HDQRS/ANOCA.PDT/0017, and therefore the said letter cannot confer any legal benefit on the first defendant, and that the first defendant cannot in law rely on the purported letter as the basis of any claim whatsoever in any jurisdiction against the claimant. D, a declaration that the first defendant has ceased to be an employee, staff of the claimant since the expiration of his contract on the 31st of December 2016, and therefore not entitled to any benefits, wages, emoluments, or any right howsoever described from the claimant. E, an order of this honorable court setting aside the purported fixed-term employment contract dated 1st of January 2017 with reference number HDQRS/ANOCA/PDT/0017 for being invalid, irregular, unlawful, and particularly for non-compliance with basic standard contract noted with the claimant. F, an order of perpetual injunction restraining the first defendant, his agent, previous assigns, or anyone howsoever described from placing reliance on the purported fixed-term employment contract dated 1st of January 2017 with reference number HDQRS/ANOCA/PDT/0017 as the basis of any claim against the claimant. The claimant filed along with his originating process, statement of facts, witness statement on oath, and other accompanying processes. The defendant on the 12th of February 2020 filed a notice of preliminary objection seeking for A, an order dismissing and or striking out this instant suit in limine for lack of jurisdiction of the Honorable Court to entertain and adjudicate over the suit, or in the alternative B, an order of this Honorable Court staying further proceedings in this matter pending the hearing and determination of a dispute by an arbitration tribunal stipulated in the underlying agreement, contract, and constitution of the claimant. And C, it's an omnibus prayer. The grounds upon which the objection are sought are: 1, that the claimant has not explored the dispute resolution mechanism stipulated in its constitution to submit any such dispute to an arbitration tribunal appointed by common consent. 2, that all enabling arbitration laws governing the subject matter in Nigeria provide for reference to arbitration before recourse to a court of law. 3, that this court lacked the requisite vials to hear and determine any matter concerning the claimant and defendants owing to the non-compliance of the condition precedent as stipulated by Article 26 of the Constitution of the claimant and as agreed upon by the headquarters agreement, particularly the settlement of dispute clause. And 3, those are the 3 grounds. Accompanying the application is a written address wherein the applicant distilled the sole issue for the determination of the court. I've reduced the submission into the body of this ruling. In response to the notice of preliminary objection, the claimant respondent on the 25th of February 2020 also filed a written address canvassing arguments in opposition to the preliminary objection, wherein the claimant equally distilled a sole issue for the consideration of the court. I've reduced that also into the body of this ruling. I will now go straight to the decision of the court. after a careful consideration of the notice of preliminary objection filed by the defendants and response to same by the claimant, submissions and authorities cited in their respective written addresses and the reply on point of law, the germane issue from consideration is whether or not this case is premature, incompetent, and thus divest this court of its jurisdiction. First, I need to consider a preliminary concern raised by the learned defense counsel. That is, the claimant, in attempt to resist the preliminary objection, caused the filing of written address in response dated 25 February 2020, that is more than 7 clear days stipulated by the rules of this court, consequent upon which is urging the court to discountenance this as an irregular process before the court. By Order 17, Rule 1, Sub Rule 10 of the Rules of this Court 2017, it provides those, and I quote, where respondent served with a motion or notice intends to oppose the application, the respondent shall file a counter affidavit, if any, and a written address within 7 days of service on the respondent of such application. An advance copy of the counter affidavit and written address shall also be forwarded to the claimant and any other party, unquote. Defendant filed its preliminary objection on the 12th of February 2020, while claimant filed its response on the 25th of February 2020 with a difference of 13 days. However, after a careful perusal of the case file, there is nothing to show when service was effected on the claimant to aptly determine if it falls short of the provisions of the rules quoted above. Assuming without conceding that claimant failed to file within the prescribed time allowed by the rules of the court, can the court discountenance the said processes, or is the said response irregular before the court? By Order 5, Rules 1 and 3 of the Rules of this Court 2017, which provides, and I quote, failure to comply with any of these rules may be treated as an irregularity, and the court may give any direction as it thinks fit. The court may direct a departure from these rules where the interest of justice so requires, unquote. Flowing from the above and in the exercise of my discretion judicially and the interest of justice of this case, I wish to depart from the provision of Order 17, Rule 1, Sub Rule 10 of the Rules of this Court and hold that the claimant's response to the defendant's preliminary objection is proper and thus competent before this court. I so find and hold. Now to the main crux of this application, which lies in the fact as argued by the defendants that by Rule 23 of ANOC Constitution and Article 26 of ANOCA Constitution, of ANOCA Constitution and the headquarters agreement between the claimant and government of the Federal Republic of Nigeria clearly demonstrate the existence of settlement of dispute clause, which operate as a condition precedent that must be complied with before a court can assume jurisdiction. The claimant in response argued that Rule 23 cannot be invoked by the defendants to cause the case to be struck out or for further proceedings to be stayed, as the scope of jurisdiction of dispute to be referred to arbitration is limited to those stated therein, that is, members of ANOCA and the federal government. That the defendants, not being members of ANOCA, are not privy to its constitution. Claimant admitted that there is an arbitration clause in the constitution of the claimant and the Federal Republic of Nigeria, but there is no agreement between parties before the court depriving the court from its jurisdiction to entertain the suit, as the relationship between parties is strictly an employment relationship. The defendant read its reply on point of law and in response stated that the contention of the claimant is misleading, as they are agents of the association, being the president and chief of staff of the association. Therefore, they are entitled and privy to benefits from the constitution of the claimant, and that the claimant has not shown in any way that they are not parties to the constitution. It is tried law without equivocation, as same is long settled, that jurisdiction of the court to hear and determine a case is the bedrock, the foundation, and the blood that gives life to a suit. See the case of Olumoye and others with Adelakun, and other citation is provided. The case of Attorney General of Kwara State and Adeyemo citation is also provided. The case of Society, BICSA and others versus Chazin Industries Limited citation is equally provided. Jurisdiction is equally the authority which a court has to decide matters that are litigated before it, or to take cognizance of matters before it in a formal way for its decision. Such authority is controlled or circumscribed by statute creating the court itself, or it may be circumscribed by statute, subcircumscribed by a condition precedent created by legislation which must be fulfilled before the court can entertain the suit. Authorities abound that where a court lacks jurisdiction to hear a matter, the entire proceedings, no matter how well conducted, will amount to a nullity. The Apex Court, in its decision in the case of Peter AC versus Nigeria Ports Limited, appeal number SC.63/2006, a judgment delivered in June 2018, where the Apex Court recapped the age-long position of the law that jurisdiction of the court is determined by the plaintiff claim as endorsed in the writ of summons and statement of claim or statement of facts in this instance. I've perused the claimant's general form of complaint and statement of facts, and both disclosed by paragraphs 2 and 3 of the statement of facts that the first defendant was the chief of staff to the second defendant, who was the president of the claimant. The crux of the claimant's claims lies in the fact that the second defendant, upon the expiration of the first defendant's contract on the 31st of December 2016, lacked the requisite power to solely extend same without recourse to the claimant's executive board or constitution. Now the claimant has argued that the defendants have not shown credibly that they are privy to Rule 23 of ANOCA and Article 12 relied on by them to avail their claims in this instant case. By Rule 23 of ANOCA of the Constitution of the Association of National Olympic Committees, it provides, and I quote, the subtitle is Disputes and Appeals. Quote, any decision by the General Assembly, the Executive Council, the President, or the Secretary General of the Association that is final in nature, that is, where there is no further appeal or formal requirement for review or mediation within the association, about which a NOC, a continental association, or a voting member of the Executive Council has a dispute, shall be referred to and submitted exclusively by way of appeal to the Court of Arbitration for Sport. The Secretariat, which is located in Lucerne, Switzerland, and pursuant to the Code of Sport-related arbitration. The decision of the Court of Arbitration for Sport shall be final and binding. The time limit for such an appeal is 21 days after communication of the decision to the person Continental Association or NOC appealing, unquote. Article 12 of Headquarters Agreement between Association of Nigeria Olympic Committees of Africa, ANOCA, and the Government of the Federal Republic of Nigeria provides those, and I quote, in event where the Government of the Federal Republic of Nigeria and ANOCA are unable to settle either amicably or through negotiation any dispute arising from the interpretation and or implementation of this agreement or any other additional agreement, the matter shall be referred to 3 arbitrators appointed by mutual agreement by both parties, unquote. It is worthy of mention that the defendants in this suit relied on Article 26 of the Headquarters Agreement, particularly the Settlement of Dispute Clause, to say that the claimant has not complied with the condition precedent for arbitration before rushing to the court. I perused the said article relied upon by the defendants, and I find out nowhere where Article 26 provides for arbitration. Rather, the provision for arbitration was made via Article 23 relied upon by the defendants. An important question to ask here is, are the defendants privy to Rule 23 of ANOCA and Article 12 of the Headquarters Agreement? By the case of Coast Oil Limited and Tuboscope Vetco International, and another citation is provided, the Court of Appeal held that the general principle of privity of contract is an elementary principle of law. Now, the doctrine of privity of contract is to the effect that a person who intends to enforce a contract will show not only that he gave consideration, but also that he is a party to that contract in law. A contract exists only between the parties to it, A person who is not a party to a contract cannot sue upon it. By the doctrine of privity of contract, a contract cannot confer right or impose obligation arising therefrom on any person except parties to it. Put simply, a stranger cannot acquire rights or incur obligations arising from a contract to which he is not a party. See also the case of Richer versus NBCI citation is provided. The case of Rebold Industries Limited versus Mogreola. Yes, citation is also provided. The defendants have argued that by virtue of their by virtue of their position in the claimant organization, they are privy to Rule 23 of ANOCA and Article 12 of Headquarters Agreement. A cursory perusal of the Constitution of the claimant via its definition and interpretation section defines quote and unquote members to mean NOCs and continental associations, which are members of the association as described in Rule 7. Continental association by the definition section includes the claimant. By paragraph 7.2 of the claimant's constitution, it provides that, I quote, every continental association recognized by the IOC is a member of the association subject to this constitution, unquote. As reiterated earlier, the second defendant is the president of the claimant, who by Rule 13 is a member of the Executive Council, which by the definition section is the organ of association. It follows, therefore, that the second defendant is a key member of the claimant, and he can benefit from the Constitution. A question arising therefrom is, has the Constitution provided for arbitration with respect to the claims of the claimant? I answer in the negative on the reasoning that Rule 23 provides for arbitration on the grounds of an appeal from the decision of quote and unquote the General Assembly, the Executive Council, the President, or the Secretary General of the Association that is final in nature, that is, where there is no further appeal or formal requirement for review or mediation within the association about which a NOC, a continental association, or a voting member of the Executive Council has a dispute shall be referred to and submitted exclusively by way of appeal to the Court of Arbitration for Sport. I've carefully examined the documents before the court, and I find out nowhere where the decision of a General Assembly, the Executive Council, the President, or the Secretary General of the Association was placed before the court to activate appellate jurisdiction of the Court of Arbitration for Sport, and not this court. It is pertinent to equally state that the provision of Rule 23 does not provide that the claimant must first of all go through the process of arbitration before they can come before this court, as Article 23 specifically provided for arbitration on the ground of appeal from the decision of the General Assembly, the Executive Council, the President, or the Secretary General of the Association. To me, Rule 23 does not avail the defendants in this instant case, as they have failed to show that the condition precedent, that is, the arbitration clause, relates to their case and must therefore be fulfilled before filing a suit against them in this court, as the said Rule 23 specifically mentions that arbitration is only on the ground of appeal as it relates to organs captured supra before the Court of Arbitration for Sport. The defendants have also argued that by Article 12 of the Headquarters Agreement, this court lacks the requisite power to adjudicate on this suit. I've painstakingly examined the Headquarters Agreement, and I find it glaring that the provision pertains to where there is a dispute between the federal government of Nigeria and ANOCA, and not between ANOCA and its members, as in this instant suit. The issue in this instant case is between the claimant and the defendants, who is the president of the Claimants Association and is chief of staff, primarily about the extension of terms of contract of the first defendant. There's nothing to show that the dispute affects the federal government in order to avail the defendants as argued by them. It is the law that a constitution or statute or documents must be construed literally, given the words in such constitution or statute or documents their ordinary grammatical meaning, as the duties of the court is to accord clear and unambiguous provisions of the constitution or statute or documents the literal construction, and not to amend, add, subtract, or alter the provisions thereof. See the case of Borime versus Olagbegi and others, citation is provided. The case of FIRS versus CNOOC, exploration and production, and another citation is also provided. It is thus obvious from the above stated that the defendants are not privy to Article 12 of the Headquarters Agreement, and also that the provision of Rules 23 of the Constitution on Arbitration does not serve as a condition precedent to filing this instance case. It is in the light of all stated herein before that I hold a considered view that this suit before this court is not premature, as the court possesses the jurisdiction to adjudicate and entertain same. It is upon this basis that I equally find that the alternative prayer is unfounded and is thus discountenanced. The defendant notice of preliminary objection therefore lacks merit and same is dismissed, consequent upon which I hold that the claimant case is competent and it shall proceed to hearing. That is the ruling of this court. No orders to cost.
As the court pleases, my lord.
As the court pleases, my lord.
So what
my lord,
date?
we're grateful. Not a date convenient by the court.
June 23rd.
Convenient, my lord.
My lord, subject to the directive of the court, we would want to take our 30 days within which to file our substantive defense to the statement of claim.
You haven't filed?
No, we haven't filed because the rules does stipulate that a challenge on the grounds of arbitration agreement should be filed before any step is taken on the merits. So we had to actually file that first for the court to determine this. So
well, I give you 14 days. I give you 14 days to file. I'm abridging time.
As the court pleases.
I'm giving you 14 days to file.
My lord, if I may respectfully ask for 21, because the clients are out of jurisdiction, they may have to come into the post to their witness statements on oath. They're actually in Switzerland. They're not within the jurisdiction of this court presently.
They can do so. They can do so before. Learned counsel. They can do so before a notary public outside of this country, or look at the rules of this court. I know there is a provision whereby they can do so before a recognized person, either a notary public or go to the Embassy of Nigeria, where they would, depose to it, and then copies will be sent just to every time and to save cost anyway.
As a court
we're most guided. We're grateful.
We're grateful.
So we have come to the end of this. Well, tentatively, let's fix 29th of June. 29th of June.
29th of June is convenient to the defendants.
My lord, it's convenient.
Yes. It's a Tuesday.
Yes, my lord.
For report of compliance.
As the court pleases.
Very well, we've come to the end of today's proceeding.
As the court pleases.